that. Well, hello everyone. Today we're gonna do the tenant rights webinar. My name is Alex Escobedo, and I am the Communication and Events Coordinator here at Lawyers Committee for Better Housing, or LCBH for short. We are doing this online information session to provide you with current updates on tenants' rights during the COVID-19 crisis, tips on communication with landlords, and if you can't pay rent, and information on the eviction process in Chicago. I do want to mention that if you have to hop off the live stream, or if you can't see it at this time, it will be on our Facebook page later after the live stream is over, and it will also be available on our YouTube page. I am happy to introduce our speaker for today, Morgan Schumann. She's a staff attorney here at LCBH and manages Rent Intervention, an online free resource for Chicago renters facing housing issues. If you have any questions, please write them in the comment section on the Facebook live stream. I'll monitor and then message them to Morgan.
Excellent. Thank you for the introduction, Alex. I'm excited to get started today and hopefully be able to offer you a little bit of information that will be a comfort during this difficult time for many of us. So as we'll be going through, like Alex said, please feel free to ask any questions and send those over to us. I want to be able to make sure that if you have questions or concerns, we can do what we can to get those answered for you. Things that are more general, we'll be able to answer on the webinar today, but I would also encourage you, if you haven't yet, to go to rentintervention.com and check that out. That's a great tenant resource that you can go to if you need to get more information about your specific situation. So please consider going to rentintervention.com after this webinar if you have additional questions or you want to connect with an attorney or get more information about your rights. So with that, we're going to go ahead and get started. As we jump in, just to keep in mind that this is a webinar that is designed for Chicago tenants specifically, and it's really geared at tenants that pay market rate rent for your apartment. So not so much for tenants that maybe have a subsidy or live in public housing. So keep that in mind. There are lots of organizations that might be able to help you or offer resources, and some of what this presentation includes will be applicable to those tenants, but you want to make sure that you consult an attorney. I encourage you to check out Legal Aid Chicago if you're in that situation. So with that, we're going to go ahead and jump in. I've got our agenda for today. We're just getting started and we'll expect to go for about an hour, maybe a little bit less, but certainly if there's questions, we want to have the time to be able to cover everything that you want to know. So the main topics that we'll be covering today is, first and foremost, a little bit about what you can expect if you are worried about not being able to pay rent. And this includes helping to make sure that you understand the eviction process. So what actually happens if your landlord is threatening you with eviction, and what are the notice requirements? How much notice will you receive? What format would it look like? And what can you do if you receive a termination notice because of an inability to pay rent or for some other reason? Throughout the presentation, we'll be touching on issues that are specific to the COVID-19 situation. There are some additional protections that tenants have because of the COVID situation that are a little bit different from what normal tenant protections look like in Chicago. So we'll be touching base on what those are. We'll also talk about a couple of common scenarios and situations that tenants find themselves in, including what to do if your landlord threatens to lock you out or actually does lock you out from your apartment, or what you can do if your apartment needs repairs and your landlord is refusing to make those repairs. So some of these are really common situations, unfortunately, and we want to help you understand what your rights are and what you can do to exercise those rights. All right. Now, as we jump in, I just want to set the stage a little bit and help you understand that you are not in this alone. If you're having trouble paying rent, this is something that at least 1 in 8 renters over the past 2 years have experienced having to move, not by choice. 74% of low-income renters are paying more than half of their income toward their rent each month. So if that's you, that can make it really hard to absorb the cost of this COVID situation, maybe you've lost your job or lost hours or wages, you might be really struggling to figure out with how you're going to keep up with your rent and what your options are. So just remember that you're not alone in that situation, and that thousands of renters also fail to live in rental units that are basically safe and habitable. So if there are repairs that need to get done, you have the right to live in an apartment that is up to building code. And part of what this webinar is going to teach you is what you need to know to get your landlord to actually go ahead and make the repairs that you really need. So with that, we're going to jump in and start by talking a little bit about the eviction process and about the very first step in the eviction process, which is receiving a termination notice from your landlord. Leases can be terminated for a number of different reasons. So the most common one that we see is if a tenant is unable to pay their rent. We'll sometimes see a landlord provide a 5-day notice. And remember, this webinar is specific to Chicago. So if you're in other parts of the country, you'll want to check what laws are applicable in your state or your municipality. But in Chicago, tenants have the right to get a 5-day notice if they are past due on rent and the landlord wants to be able to move forward with an eviction case. If you find that you get a 5-day notice, it's really important that you know this one thing, and that's that only full payment of the amount of the notice is able to cure it, which basically means fixing the notice and preventing your landlord from being able to file an eviction case against you. So if you receive a notice and you try to work out a deal and you pay your landlord part of what it is that they say that you owe, then that might not be enough to protect you. Even if the landlord tells you verbally that that's okay, or that that'll help, or that they'll hold off filing, they might have a legal basis to file the case if you pay anything less than the full amount on the 5-day notice. If you get a 5-day notice and you do agree with your landlord to a different payment plan, it's really important that you put that payment plan in writing and that you have your landlord agree in writing that they are withdrawing the 5-day notice that they gave you, so that that cannot become the basis of a future eviction filing. 2 other kinds of termination notices for you to be aware of. Next one is a 10-day notice, which you'll typically see for a breach of a lease. So if your lease has a rule in it that you broke, then maybe you would receive a 10-day notice from your landlord. And if you receive a 10-day notice, the main thing that you want to do is figure out, what it is that your landlord is saying that you did that was in violation of the lease, and do what you need to do to resolve the situation. And you want to follow up with your landlord in writing, let them know what it was that you did, or if you disagree, that you broke a term of the lease, follow up in writing to confirm what it is that your behavior was, or what the situation was, that indicates that you have done what it takes to resolve the situation within that 10 days. And then the final possible terminate, well, not the final one, but the final main one that we see most often is a 30-day notice. And now a 30-day notice is for a no cause eviction situation. So this means that your landlord does not necessarily need to give you any sort of reason why they're terminating the lease, but landlords can typically end a month-to-month rental agreement just by giving the tenant 30 days advance notice. Related to this, if you receive a 30-day notice, there's a couple of things to think about. One of those is that the name is a little bit deceiving, and the 30-day notice can actually only end your lease or your rental agreement at the end of a rental period. So most tenants, for example, pay their rent from the first of the month through the last day of the month, and that would be the total rental period. So if on, let's say, May 15th, your landlord gives you a 30-day notice and you pay your rent every month on the 1st, your landlord can't terminate your lease on June 15th. They have to give you the entire final period. So they have to give you all the way until the end of June. So if you get a 30-day notice, keep that in mind. Another thing to keep in mind is that landlords are not allowed to give 30-day notices for reasons that are discriminatory or retaliatory. So if you have a reason that you think that your landlord is giving you a 30-day notice and that they're retaliating for something, maybe you requested repairs to the unit and instead of making the repairs, they gave you a 30-day notice, that would be a good time when you would want to consult with an attorney or go to rent intervention and see what can be done about addressing that 30-day notice. One last point of mention here is that generally a landlord can offer a 30-day notice, and even if a landlord thinks that the tenant has not been keeping up with rent, usually they'll give a 5-day notice, but we occasionally see landlords giving 30-day notices instead. If you think that that applies to you, there are certain protections for some tenants if they're covered by the CARES Act, which is the federal stimulus package that included some tenant protections. And we'll get into that a little bit more later in the webinar. But if you think that the true reason why your landlord is trying to end your lease or your rental agreement with a 30-day notice is because you're behind on rent, you'll also want to touch base with rent intervention or try to talk to an attorney who might be able to analyze to see whether you're protected by the CARES Act and whether that notice might actually be in violation of that act. Just going to pull up the chat here real quickly to see whether we've gotten any questions so far. Please keep in mind again that if you have any questions as we're going throughout the webinar today, that you can send those directly over through the Facebook Live Messenger over to Alex, and he will send them to me and I'll be able to answer them live. If you've got questions after the webinar, or if you're watching from a recording after the fact, you can certainly go to rentintervention.com and you'll be able to find a lot of answers to your questions there. Or if the answer is not on the website, you'll be able to connect with an attorney that might be able to help you out as well. So let's go ahead and jump in to a little bit briefly about what the eviction process actually looks like. And this is a main area that sometimes tenants are confused because they're thinking about evictions as a one-time thing, you know, a single occurrence. I got evicted today. And really an eviction is more of a process. And so what I want to walk through is what all of the steps are so that you can understand if your landlord is threatening you with eviction, or if you think that an eviction case has already been filed against you, or if you're worried about the sheriff coming out and actually kicking you out of your house, then I want to make sure that you understand which phase of the eviction process you might be in. So the first step here is that termination notice step. So this is what we were just talking about. And this is where the landlord has to give you a written notice telling you that your tenancy is coming to an end unless you do something. So with a 5-day notice, unless you pay the full amount that's due, with a 10-day notice, unless you fix whatever the problem was. And then you might or might not have the ability to fix a 30-day notice. So the termination notice is step one. That's, you know, what tells you that your tenancy might be coming to an end unless you do something. Step two in the eviction process is when your landlord actually goes to the court and files an eviction case against you. And this is actually, unfortunately, you know, a really big step, and that can really harm tenants, even if the landlord is ultimately unsuccessful in eviction court. Because when an eviction case is filed, for most reasons, it's going to be a matter of the public record, which means that it would be available if somebody were to search your name on like a database of potential tenants, or if you're trying to apply for a new apartment, or even potentially showing up on your credit report as having an eviction case filed against you. So the very filing of the case can sometimes really hurt tenants, and it is public record in Chicago, unless at some point down the road in the process the case becomes sealed. And once the case becomes sealed, if that's negotiated maybe as part of a settlement agreement down the road, then you could maybe get that filing removed from your record. But in the meantime, as soon as the landlord files a case, it can become significantly harder for you to be able to find a different apartment if you're looking at moving. So the reason why I mention that is because the point of time between steps 1 and 2 is one of the most critical times for tenants that are worried about potentially facing eviction, because this is the time where you might be able to really negotiate with your landlord and come up with some sort of an agreement that is, we call it pre-eviction. It's before the eviction case is filed. It's before you would end up getting that ding on your credit report or your public record. And if you can reach a deal with your landlord that works for you there, that's something that is going to be able to potentially keep you out of eviction court. It's something that's going to be able to potentially keep you in your apartment. And that's, you know, a really powerful thing. You've got a big incentive to try to work with your landlord to create a good situation before a case is filed. If a case is filed, then you have the right to, of course, learn about that case. And the way that that happens, sometimes you might learn about it informally because your landlord might just tell you that they hired an attorney or that they filed a case. But you have the right to get it's called a summons, and it's basically a paper from a court that tells you when it is that you are required to go to court to appear in the case. So you will receive a summons either because the sheriff will knock on your door to deliver a copy to you. You might get a copy from a special process server, which is more like a private detective that your landlord would hire to give you a copy of the summons if the sheriff is unable to serve you. Or if after several attempts, the special process server and the sheriff were not able to give you the summons, then you might be served through what's called posting, which is where a copy of the fact that the case was filed is posted in a prominent place, and you might receive a copy of the summons in the mail to your building. So keep that in mind. There are multiple ways that you could be served with eviction papers, but that will just tell you that a case has been filed, and it will tell you when your court date is. If you receive a summons or you learn that a case was filed, again, this is a great point to make sure that you try to reach out right away and seek the advice of an attorney, of legal help. You can do that by going to rentervention.com, and you can go to rentervention.com to get legal help any point in this process. So if you've just gotten a 5-day notice, you can come and we might be able to advise you on how it is that you can handle that situation. If you learn that a case was filed, we can jump in at that point. So at any point in this process, but the earlier the better, you'll be able to come to Rentervention and get some advice and information about what your options are. So the case, would be filed, you would receive a copy of the summons, and then step 3 is when you actually go to court. In eviction cases, they are typically proceed very quickly, and they're set for trial on the very first day that you would appear in court. They're by default set for trial in front of a judge, but it is important for tenants to realize that they do have a right to request a jury trial. And so if you would like your case to be able to be heard by a jury instead of by the judge, you have that right, and that's something that can really oftentimes benefit tenants to have their case heard by a jury of their peers. You also have the right to ask for time to find an attorney, and typically the courts will grant about a week for you to talk to an attorney and see if you can get somebody that can represent you in your case. So if you do have your first court date up and you have not sought legal counsel, you should consider asking the judge for a week to look for an attorney, and the judge will set the case for the following week. So you've got a little bit of time. So I would encourage you to think about that. And then especially if you do request a jury trial, you'll be able to have time to request discovery from your landlord. And that's if you want to request any sort of documents or information, ask your landlord to answer questions that you have about what their claims are. So there is that process, and you'll have more time to engage in that if you do make a jury demand. This is all things that if you're facing an eviction case and you receive a summons, I would really encourage you to seek legal advice that is specific to your situation, because it can The advice can really differ depending on what your goals are and what the situation is. So I'd encourage you to go to reintervention.com, but recognize that you have that right to get some discovery in the case. You have the right to request a jury, and you have the right to ask for a week in order to talk to an attorney and try to get them to represent you in the case. All right. Step 4 of the eviction process is the final resolution in court. So once your case is set, it could go different ways. It could actually go to trial, and that's when the judge or the jury would make a determination about whether or not your landlord is entitled to possession of the apartment, to getting the keys back and having you move out. And also, oftentimes this includes whether the landlord is entitled to any sort of money damages. So this might be back due rent amount, most of the time, maybe court filing fees. And then finally, the sheriff would actually come to execute an eviction order. Sorry, I'm going to back up one more step. So I mentioned trial as a potential resolution in court. By far, though, most cases actually don't resolve through trials. Most cases resolve because the parties agree to a settlement agreement. And as a tenant, there is a lot of reason why you would potentially want to agree to a settlement instead of going to trial. In a settlement, you can agree usually down one of two paths. One path is saying that you're agreeing that you'll move out by a certain date and that you will give over the keys to the landlord. And in exchange, the landlord will typically agree to dismiss the case. So there's not an eviction order that's ever entered by the court. There's nothing on the public record that says that your landlord was successful in evicting you. Instead, it's just an agreed settlement order. And if you comply and you move out, then you would be entitled to have your landlord dismiss the case. As a tenant, you might be able to get some other protections or other benefits out of the situation. For example, if you owed past due rent, your landlord might agree that they would waive that past due rent in exchange for you moving out on a certain date, that might be earlier than they would otherwise be able to get you to leave the apartment. So that's one thing that you might be able to get. This is another area that you might be able to negotiate for having the record sealed. So that's another thing that you can consider when you're thinking about negotiation and settlement. The other main path, other than moving out, is trying to work out a repayment agreement with your landlord. And this is something that, again, would be a formal settlement agreement between you and the landlord or the landlord's attorney, where you would agree to a plan that you would make whatever payment by whatever date you all agree to. And it usually spreads the back due amount over a period of weeks or months to allow you to get caught back up. A landlord doesn't have to accept a payment agreement like this for a pay and stay, but they certainly might, especially if you have been a good tenant before and maybe you're just down on your luck with this COVID situation or otherwise. They might want to keep you and just work out something where you'll be able to make payments toward what's owed. But you do have to be very careful. You never want to agree to a payment plan or a settlement agreement that you are not 100% sure that you'll be able to keep. Because typically, if you break your end of the agreement, if you're not able to make a payment, your landlord is typically able to come back to the court and get an automatic eviction order, which means that they don't have to start back at step 1 here. They can jump all the way to step 4 and get that eviction order that they could give to the sheriff to execute. Okay. And then finally, back to step 5. Where the sheriff actually comes out and executes the eviction order. So the main thing to know here is that only the sheriff can actually remove you from your apartment. Once the landlord gets an eviction order, they can't just come the next day and tell you that you need to turn over the keys and leave. You have the right to be there until the landlord gives the eviction order to the sheriff, and the sheriff actually comes out to remove you from the apartment. All right, I'm going to take a quick pause right now. So if you have any questions and you're watching, please go ahead and send those over to me. If you're hearing my dog bark in the background, I apologize for that. I am, like many people, working from home right now. All right. So we are jumping now into a little bit about what it is with the court system right now and tenants' rights that's specific to the COVID-19 situation. And we don't have time today to cover every single scenario, but the idea is that we'll just be able to give you some information about the things that seem like they're the most common issues for tenants right now. And like I said, if you have questions about any of this, please go to rentervention.com and interact with Rennie. He's our Rentervention chatbot, and he can give you a lot of information that's specific to your circumstance. If Rentervention's not the right place to help you, maybe because you live in Illinois but not in the city of Chicago, or if you're a subsidized tenant, Rentervention is going to be able to direct you to the correct resource. And then Rentervention can also give you advice about how it is that you can talk to your landlord, different ways that you can communicate, templates for letters. So lots of different things that you can get from Rentervention. So I'd encourage you to check it out if you haven't already. All right, so let's jump in and talk a little bit about what the protections are for tenants that specifically relate to eviction during the COVID situation. So the very first one right here is that the sheriff is not currently enforcing eviction orders. So when you think back to the stages that we were just talking about, this is step 5. This is the last bit of, apologize for my dog there. This is the last bit of the process where the sheriff is not going to come out after your landlord has already gotten an eviction order. They're not going to come out and remove you physically from your apartment right now during the public health crisis. So that's defined as the amount of time where Illinois is under a disaster proclamation according to the governor's office. So the last disaster proclamation was actually set to expire today. I believe that it is being extended until the end of May. So keep that in mind right now. Even if you were to have gotten an eviction and gone to court before this whole thing happened with the COVID situation, maybe you got an eviction order entered against you 6 weeks ago, but you're not at risk of the sheriff actually knocking on your door and removing you from the apartment until after the disaster proclamation for Illinois has been lifted. So that's the first protection for tenants. The second protection for tenants comes earlier in the process. So right now, the Cook County Court is not hearing eviction cases that have already been filed until at least May 18th. So you, except in an emergency situation, for the most part, you're not going to have a case come up in front of a judge in eviction court before May 18th. And that deadline also might get pushed back given the extension to the stay-at-home order. So this is kind of like a pause button on cases that were already filed. There's a new protection that just came from the governor's office last week. And this is now that landlords are actually not supposed to begin an eviction case, except in narrow circumstances where there's a tenant that is a direct risk to health and safety, a direct threat, or a severe risk to property. So if you want to see the exact language of that, you can check out the governor's executive order from last week. But this, should protect tenants that are fearing eviction right now because of their inability to pay rent, which is, the most common situation that we're seeing. It is, however, narrow. It doesn't prevent you from having to pay the amount of rent that you owe. It only prevents the landlord from being able to actually file the case against you in court until basically until this is lifted. And I don't know exactly when that's going to be. I would expect it to continue at least through the end of May. It might be longer than that, but for now, that's what the protection is. Again, any questions, feel free to send that over. If you're worried about your landlord filing an eviction case, you also are potentially protected by a federal statute, which is the Federal CARES Act. And the Federal CARES Act is a law. It's the same law that gave most people the $1,200 through that stimulus package. It was a component of that same act. And what this does is it only applies to certain tenants that fall into kind of two main buckets. One of them is if you're a tenant that lives in a building that has a mortgage that's federally backed. So this could be, it could be a large building, it could be a small building, but if your landlord has a mortgage that's backed by Fannie Mae or Freddie Mac, or another federal type of mortgage, maybe an FHA type of mortgage, that would protect you under the CARES Act. And then in addition, buildings that generally benefit from federal subsidies are also included. So this is the one bit that I would tell you, if you're a Section 8 tenant, or you're living in public housing, then this very well might apply to you. But like I said, I'd encourage you to contact the folks over at Legal Aid Chicago if that applies to your situation. But if the Federal CARES Act applies to you, then your landlord should not be able to give a termination notice. So going all the way back to step one in the eviction process, they shouldn't be able to give you a notice ending your tenancy because you're late on rent, or otherwise trying to end it, giving you a 30-day notice or something like that. They're not supposed to be able to charge any late fees, and they are not supposed to be able to file any eviction case against you until at least July 25th of this year. So that, is a longer protection, and that's also the only protection here that prevents you from being able to have late fees assessed against you. Although there are caps to the amount of a late fee that can be charged. And so that's where I'm just wanting to briefly cover that. At the bottom here, you'll see that there is a protection for Chicago tenants specifically, which is under the residential landlord tenant ordinance. So we'll talk more about that later in the presentation, but the brief summary is that most tenants in Chicago live in a building that's protected by the RLTO. The only time you're not going to get that protection is if you're living in a small building that's got 5 or fewer units and your landlord also lives in the building with you. But if that doesn't sound like where you live, then you would be protected to make sure that you're not getting any excessive late fee. So nothing more than $10 plus 5% of your monthly rent. Excuse me, I'm actually noticing there's a slight mistake on the slide here. 5% of monthly rent over $500 is what the RLT allows. So check that out if you have the suspicion that your landlord is charging you late fees that are in excess of that amount. Okay. And once again, I'm keeping my eyes on the chat. So if there are any questions at all, please feel free to reach out and Alex will send those over to me. All right, so we're going to jump in, and I'm not going to be able to answer all of the questions here right now, but this gives you some ideas for what it is that your friends and neighbors might also be asking, or questions that you might be wondering related to the COVID situation. So you might be wondering what it is that you can do if you can't afford to pay your rent, whether you can be evicted if you can't afford to pay, whether you should participate in a rent strike, what to do if your landlord is refusing to make repairs in your apartment. Do you have to let your landlord in if they want to show the unit to prospective tenants? Short answer there is no, you don't. You're protected right now because of the COVID situation from your landlord trying to show the unit while you're living there. If your lease is ending but you can't move, what can you do? So these are all situations that Rentervention will be able to give you guidance on what to do and potentially connect you with an attorney that can answer more detailed questions that you have about it. But as you're looking through here, if there are any questions that you have that you specifically want me to go over in detail on this presentation, just let me know. But a quick preview of what it is that you might be wondering. Another point on here, point 7, are you allowed to move during the stay-at-home order? Moving is considered an essential service. So if there's a reason why you have to leave your home, there is an ability to hire movers and move even under the stay-at-home order. We talked already about late fees. We talked a little bit about whether or not you can get a 5-day notice, depending on whether you're protected by the CARES Act. Number 9, we haven't talked about so much yet, but could your landlord ask about your health status? This is something that you are not required to disclose to your landlord. So if they're asking it and you feel uncomfortable giving that information, there's no reason why you should be obligated to share that personal health information. On the other hand, it's something that some tenants choose to disclose to their landlord, maybe because they are trying to work out a payment agreement with the landlord and they're trying to elicit sympathy or empathy. And that is something that I would encourage you to think about if you think that it would help in your particular situation. And then 10th here, what should you do if you're locked out or worried about becoming locked out? And this is a big concern for a lot of tenants right now because the eviction process, the court process is slowed down. And so we're seeing that landlords, might be turning to self-help in order to try to remove a tenant by pressuring them or harassing them or telling them that they have to leave or changing the locks or removing a door or window. All sorts of ways that a landlord might try to kick a tenant out. And so we're going to talk a little bit about what your protections are there. All right. If you're just joining us, welcome. I know we're live on Facebook right now, so thank you for tuning in. My name is Morgan Schuman. I'm with Lawyers Committee for Better Housing and the Rentervention Project. We are just going through right now a description of what tenant rights are in Chicago specifically. So if you're just joining, welcome and thank you for tuning in. You can send any questions over and I'll be answering those live at the end of the webinar. So we're transitioning now. We've talked about the eviction process and about special considerations during the COVID situation. But now what we're going to talk about is protections that that most tenants have, I should say, under the residential landlord tenant ordinance. And the purpose of this ordinance is really to protect tenants in common situations. And the first thing that you want to do, if you think you might be protected by this or that you've got a situation that the residential landlord tenant ordinance deals with, is to determine whether the ordinance applies to you. So remember what I said from earlier, that's going to be if you're living in a building that is less than 6 units or 6 or fewer units, that is not owner occupied. So if the owner of the building does not live in the building with you, then you're going to be protected from this ordinance. There's one kind of exception to the exception, and that is dealing with lockouts. Every single residential tenant in the city of Chicago is protected by the residential landlord tenant ordinances, protection for tenants related to being locked out of your apartment. So when we talk about that, it doesn't matter if your landlord lives in the unit with you. If you're worried about being locked out, the protection in the RLTO is going to apply to you in Chicago. Okay. Some of the things that the RLTO covers is the total maximum late fee that's allowable, provisions that your landlord might not be able to legally have or maintain within a lease, descriptions of what tenants' rights are with respect to building conditions, lockouts, like I said earlier, and also protections for tenants dealing with the return of security deposits. And we won't have time to go into all of that, but all of it is covered on Rentervention. And if you have a question about anything specifically, feel free to send it over. But the one bit that I really want to touch on today that is important is this lockout provision. So I mentioned that a lockout is not only what you would expect a lockout to be. Of course, if your landlord comes and tries to change the keys to your door, doesn't give you a copy, or maybe changes the keys to the master door to the building and doesn't give you a key, that can be a lockout, of course. But a lockout can also be something that might be more subtle. So it might be your landlord disconnecting your utilities, turning off the water, turning off your electricity on purpose. Anything that is done with the intent of trying to force you to voluntarily vacate your apartment would be considered a lockout. And there's some examples on the presentation here. So what you can do if you're locked out, you've got, a few different options, but you have the legal right to be in your apartment. So you can contact the police and request that they let you back in. This is usually the most effective first step, although there is sometimes situations in which the police don't realize that it is their responsibility in order to let you back in. There is a special order, and I've got a link to it at the end of the presentation, that if the if the police officer that responds tells you, that they can't help because it's just a civil issue, then I would encourage you to ask to speak to a supervisor and direct them to the general order that requires police to respond in lockout situations. So keep that in mind. If the police don't respond, I would encourage you to go to reintervention.com or find another community organization. I think Metropolitan Tenants Organization is also effective at helping tenants with lockout situations. So reach out and see if you can get somebody involved that can advocate on your behalf to get you access to the building again. That can be especially effective if your landlord is doing something more subtle with the goal of trying to lock you out, or if your landlord is threatening to lock you out but hasn't actually done that yet. Another good tip to keep in mind if you're worried about your landlord locking you out is to make sure that you always carry with you proof of your tenancy in the apartment. So this might just be as simple as having your driver's license with your address on it, or maybe you'd consider carrying a copy of your lease on your cell phone, or maybe a utility bill, something like that, that's going to show that that is in fact that your apartment and that you have a right to be there. So think about having that. And then in addition, you might have a civil remedy if your landlord locks you out or threatens to lock you out. You can be entitled to damages if you choose to sue your landlord. You can get up to 2 times rent in that type of a situation, in addition to attorney's fees. So if that's something that you are interested in, you should just know that you do have a little bit of leverage there. And that can be a good thing, even if you don't end up suing the landlord, just to be able to use that for negotiation and to really convince your landlord that it's not in their interest for them to lock you out, that's not going to help the situation. Okay. So we're going to jump into the second main thing that we're talking about today with respect to the residential landlord tenant ordinance. And this is what you can do if your landlord won't make repairs. Now, this is not something that is COVID specific, unfortunately. Unfortunately, a lot of tenants in Chicago are dealing with substandard living conditions where landlords are refusing to maintain their buildings. And so this is what you can do once you've made that initial request. Sometimes the initial request can be resolved if you simply, submit something through the building's process, if they've got a maintenance person that you can call. Sometimes having that informal communication to start is enough to get a situation resolved. But this is really what you can do if you try that and it doesn't work and the situation continues to be ongoing. What is your potential remedy? In that case, we always recommend communicating with your landlord in writing, and the residential landlord tenant ordinance has a specific process that you have to follow and gives you 3 main choices for what your potential options are if your landlord is refusing to make a necessary repair. You do want to keep in mind the type of repair that you're requesting and what, in terms of what your landlord's obligation is to it. So if you're requesting, fresh paint every year, and professional carpet cleaning on a regular basis, those are things that maybe aren't necessarily required in order to stay compliant with the building code. So that's not the type of repair that we're really talking about here. What we're talking about here are the repairs that are necessary in order to keep the building clean and habitable for you, so that you're not risking injury or harm or living in really substandard conditions. So we're talking about things like mold, a rodent infestation, bed bugs, any sort of situation like that that really is affecting your ability to safely live and enjoy the home that you're renting. So if you want your landlord to make repairs, you've tried that informal negotiation or request, and it just hasn't worked, you can send your landlord a letter, and it has to be generally a 14-day letter saying basically that you're demanding that the repairs be made, and then telling your landlord what it is that you're going to do if the repair isn't complete. And you've got 3 options. The first one is repairing and deducting. So this is typically best for situations where there's a small amount or smaller dollar amount of the repair, and you just want it fixed and it's not getting done no matter how much you've asked. It's just not happening. So if that happens, you can send a 14-day letter, say, in that letter, if the repair isn't made within 14 days, I'm going to make the repair myself or hire somebody to make the repair for me, and then deduct the cost of that repair from my rent. So make sure if you do that to save your receipt, make sure to give your landlord the full 14 days from the time that you make the request before you deduct anything. If you jump the gun and you fix the problem after 10 days or after 12 days, or even 14 days after you send the letter, but not 14 days after your landlord receives the letter, you can get stuck ending up owing that money. So make sure you give it the full 14 days from the date that your landlord receives the letter. Second option, you can withhold a reasonable amount of monthly rent. So this is probably the riskiest of the options that we've got for you. So, but in certain situations, really, if the repair is going to be more than $500 or more than half of your monthly rent, it's not permissible for you under the RLTO to just make the repair yourself. I can't, if my roof is leaking, I can't put a new roof on that's going to exceed the amount that I'm allowed to do through a repair and deduct. So in that type of a situation, if I want to stay in the apartment, my only option might be to withhold a reasonable amount of my monthly rent. But I would want to think about how I can determine what amount is reasonable. And we see tenants all the time that say, look, my landlord isn't making any repairs, so I'm just not going to pay rent. And not paying any rent is in basically every situation considered unreasonable, because a judge is going to decide at some point, if this ever goes to court, that the apartment that you're living in is worth something. It might be not worth, it might not be worth exactly what your landlord is saying that it is worth, or that you agreed to pay when there wasn't all of these conditions that are wrong with it. But if you're choosing to still live there, then the apartment is almost certainly worth something. So even in the most severe circumstances, my office never recommends that a tenant withhold, or I shouldn't say never, but very rarely recommends that a tenant withhold more than half of their rent. But you'll want to think about how serious something is. If it's affecting, one of the rooms in your 7-room house, maybe you withhold 1/7 of the rent, or have some sort of logic for why it is that you could justify the amount that you're withholding. If you're withholding for multiple issues, we encourage you to itemize it out and say what the amount of rent that you're withholding for one thing versus the other. Because if the landlord were to come in and make the repair to one thing, but not the other, you want to be able to withhold what you said that you would for each one of the individual repairs. So keep that in mind. Like I said, this is one of the trickier ones. A couple of disclaimers here. I would never recommend that you start to withhold rent, or even really repair and deduct if you already owe your landlord money, because sometimes making that withholding letter and saying that you're going to start withholding rent after you are already behind on rent just would upset the landlord and cause them to become more likely to file an eviction case against you. So really, this is going to be a much more effective strategy to get out in front of a problem. And if you really think that the apartment's not worth what you have to pay for it because of the conditions with the apartment, you want to go through this process, send the formal written notice, get all your ducks in a row, and then start withholding a portion of the rent so that you make sure that you're protecting yourself down the road. And then also the third option that you have besides repairing and deducting and withholding is breaking your lease and moving out. And this is limited to situations that are really so bad that you can't reasonably continue to live there. So that's an option for you as well. So all three of the options require that 14 days written notice. All right. You might have some additional rights. You don't have to wait the full 14 days. There's a separate provision of the RLTO statute if you're without essential services like heat in the winter or electric, that kind of a thing. So if you think that that applies to you, once again, we don't have time to go through all of the potential situations over the webinar today, but Rentervention does deal with that and can connect you with an attorney that might be able to give you some advice that's more specific to your situation if you're without an essential service like that. Another thing just to note here, if you don't know what you would say in that kind of a letter, Rentervention has a template letter that you can see an example and make edits to yourself. Or you can also use Rentervention to automatically generate a letter that can be emailed or sent via certified mail to your landlord. When you mail the letter, sending it through certified mail or sending it priority mail where you have a tracking number is the absolute best and safest way to go, because then you will have proof of the exact date that your landlord received the letter, and that's when you can start the clock running. So having proof that you sent it via certified mail or via priority mail is really effective. You can also send it by email. So if that's how you communicate, you can do that. You can even take the letter and save it on your phone and text it to the landlord, but it has to be in writing. Okay. And then there's a quick little note at the bottom there. Chicago does have a separate municipal code ordinance dealing with bed bugs. So if that's a specific issue that you have, I would encourage you to reach out and take a look at what your rights are there. But the ordinance does require your landlord not just to address the issue in your unit, but also to inspect the surrounding units on each side of you, so that it's addressed not just at a unit by unit level, but at a building wide level. Okay, I do see that a question came through, so I'm going to take a look real quick. So good question. It says here that the building says that they will only accept emergency work orders for the moment. What can be considered an emergency? I think that this is a little bit of a case-by-case situation. So if this is your situation, I would encourage you to go to Rentervention and try to talk to an attorney, generate a letter, and you'll be able to connect with a volunteer attorney that can talk to you about what your specific situation is. This is at the guidance of the state and public health officials that are really trying to encourage participation in the stay-at-home order by trying to limit people coming into the unit. And many tenants might not want a repair person, arbitrarily coming into the unit if they don't have to. But if there's a situation that's really affecting your ability to use your apartment, so especially something that, would be a safety concern, if there's electrical problems, water damage, anything that is affecting your ability to live in the unit, if your fridge is out, some stuff like that, I think would definitely be considered an emergency. So I would encourage you to think about that. Another consideration with respect to the COVID situation and landlords not making repairs is that if you send your landlord a 14-day letter demanding that they make the repair, you have to let them in to actually make the repair. So if you're really worried right now and you don't want anybody coming into your apartment, or you're trying to socially distance, then I would encourage you to think about whether now is the right time to send that letter, because once you do send it, then you do have to allow them to come in. Technically, though, the RLTO is still in place, so just because your landlord is saying that they'll only accept emergency work orders doesn't mean that you couldn't send them a 14-day letter, demand that a repair is made, and then if they fail to do it, take one of these actions. If they choose not to address the situation, as long as you're clear and you gave the appropriate notice, then you're within your rights to go forward with one of these. Are there any other questions, follow up to that, or any other questions about anything I've covered so far? Okay. Seeing none, I'll hang out on the webinar, so if anything comes up, you can continue to send those over by messages. We definitely do appreciate your attention today. I do want to draw a little bit of attention here to a few resources that you might want to take a look at. I've mentioned over and over today, rentervention.com is a great tool that you can go to where you can get information that is specific to your situation and potentially connect with a free volunteer attorney like myself or a member of our pro bono team. If you are an attorney and you're interested in helping out tenants, feel free to reach out to us and we can get you set up with that as well. In terms of other resources for tenants, if you are trying to get unemployment, if you're without work and you think you might qualify, but you're running into difficulty, there is a Chicago unemployment helpline, and I've got the number on the screen there for you, so you might want to consider checking that out. We also have a lookup tool for the CARES Act. This is not going to cover every single property that's protected by the CARES Act. You might remember this is that federal provision that limits your landlord from charging you late fees or filing an eviction case or giving an eviction notice before July 25th. And if you live in a multifamily building more than 5 units, there's a chance that your building might show up on this lookup tool through the National Low Income Housing Coalition. So you can Google that, or I can post this as a resource as well that you can check out once the webinar is over. We also have an eviction guide. This is a spreadsheet, or not a spreadsheet, a flowchart that was put together by the team at Lawyers Committee for Better Housing that can walk you through whether or not you might be subject to eviction if you are unable to pay your rent right now. And then finally, I've got a link for the residential landlord tenant ordinance summary. This is a 2-page summary from the city of Chicago. It is actually required to be attached to your lease. So if you go back in your lease, you might have a copy of it, but if not, it's available on the city's website. And it will tell you in a little bit easier to read terms what it is that's protected or covered by the residential landlord tenant ordinance. So that's another thing that you can check out. All right. Well, we are right about at 5 o'clock. So thank you all for your attention. If you've stuck around or if you've joined us partway through, thank you so much for joining. Please feel free to share this within the community so that we can get everyone, your friends and your neighbors, the help that they need to make it through this difficult situation. If we can be of any assistance, please don't hesitate to reach out to my office. I'll stick on again for another couple of minutes to take any questions that you have, but if not, thank you so much for attending. All right, thanks again.